that surely. Kindly don't inconvenience or disadvantage everyone else. So thank you Noah for that. Thank you, Lavins. That was quite insightful. Now we can go to Mary, then Gitau. Mary, are you ready?
Yes, correct.
Okay, no problem. Again, I'll let my colleague Alex begin. Then
Right.
Yes.
Kindly before the first presenter goes, mine was just a question to Lavins.
Okay, go on.
Mine was just a question to Lavins. I'm not ready to present, but it was just a question. It's about the immunity, especially the sovereign immunity, in which he explained. So I was wondering if he could explain in accordance to the BBI appeal judgment. From my reading, I understood that the immunity has some limitations in accordance now. If you are taking the readings of the BBI appeal, so if he could kindly explain further, or if he could repeat the explanation so that I can literally understand for the sovereign. Kindly.
Okay, thank you. Maybe an aspect of presidential immunity, yes, according to the BBI, it was actually a matter of contention and a matter of debate, where it was appealed from an issue to do with the issue to do with presidential immunity, whether the president has immunity. Yeah, that's a good one. Okay, in short, if you ask such a question, actually, yeah, this is the thing. This is something I wanted to tell you. So, for instance, the BBI judgment, the Court of Appeal judgment is around 1,000 and something pages. The High Court judgment is also extremely voluminous. For you to better prepare for the oral exams, there were specific issues that were asked. Don't bother with the facts too much. Don't bother with the issues. You have to bother with the issues. Check the issues. There's a list of around, I can say, roughly approximately 10 or so issues that emanated from that judgment. There was a basic structure doctrine, there was an issue to do with presidential immunity, and many others. So in brief, for you to better prepare, just check, for example, on the issue of presidential immunity. What did the High Court say? What did the Court of Appeal say? And then from there, you'll be home and dry. So for the issue of presidential immunity, if I'm not wrong, Alex works in the firm which was representing IEBC, but from a reading of the judgment, they just say that the president can be sued in his own personal capacity for acts that are a direct contravention of Article 73 of the Constitution. And there's another article to do with presidential powers. So what they basically said in the Court of Appeal judgment is the immunity only extends to acts that are done by the president that are constitutional. So if he engages in any unconstitutional acts or any acts that are, that are in breach of Article 73, in breach of Chapter 6 in general, then presidential immunity is waived. That's my take on that specific issue of presidential immunity. BBI judgment, and in the BBI judgment in the Court of Appeal and in the High Court. I'm not sure if there's one. I think there's one dissenting opinion, but there was one who dissented, but I'll cross-check on that and then maybe get back to you. But in brief, that's what the BBI judgment talked about when it comes to presidential immunity. It only extends to constitutional acts only. Maybe Lavins can expound if he has anything to add on that.
Thank you.
Right. Thank you, Senior. So who is asking the question? Your name, please.
Gitau, Samuel Gitau.
Right. Thank you, Gitau. So I talked about Article 143. So when you look at Article 143 of the Constitution, it does, make the president, immune from any legal proceedings. And legal here, it means like the immunity, will extend to the president not having, been subjected to any proceedings that will perhaps injure the office itself or the person that he is, okay? So the presidential immunity from any legal proceedings during his or her tenure is covered under Article 143. But there's a catch. When it comes to genocide or international crimes. International crimes take different aspects, okay? There's crimes against humanity and what have you. So our president, will be subjected not to the laws of our land, but to the international laws at The Hague, because Kenya, signed the Rome Statute, and you know very well what our constitution, say when it comes to international instruments, be it treaties, be it conventions and what have you. So we are party, to the Rome Statute, okay? So our president will be subject to that jurisdiction as Kenya. It's Kenya that signed the Rome Statute. So those legal proceedings, will not emanate from any courts within our jurisdiction as Kenya, but at The Hague, the ICC. So that's what sovereign immunity, is in a nutshell. Like, it's the prevention of lawsuits or prosecutions against rulers or governments without their consent. During the ancient times of when common law was developing, there was a phrase that was always said when I don't know if you could remember your law of tort. They say that a king the crown can do no wrong. That was the emphasis on that. So the crown can do no wrong. But our constitution, our 2010 constitution is quite progressive in as much as it is protecting, the president from any local legal proceedings. It sort of also protects the Kenyan people. And that's why the Constitution of Kenya begins with the sovereignty of the people. All the powers of this constitution lies with the people. So sovereignty of the people supersede any other, state authorities, state organ, or any arm of government, because it is the people that give the legislature, that gives the judiciary, that give the executive that power to govern, okay? So our president will be subject to the Rome Statute because of that. It is crime perpetrated against the people of Kenya. So that's basically what sovereign immunity is. Its pros and its cons. I hope you're now satisfied.
Thank you so much. Thank you
Awesome.
for that.
Awesome.
And then I've noticed something in the WhatsApp group. There's something that William has sent in the WhatsApp group to do with the Kenya Court of Appeal verdict on the BBI. Now, you need to take into consideration there's that aspect where they dismissed whether Uhuru had contravened Chapter 6 of the Constitution. And this is the reason why they dismissed that particular provision, why they dismissed that particular or overturned that decision of the High Court was because he was not afforded an opportunity to be heard, meaning he had not given his views. So that is the reason why. But on the aspect of presidential immunity, they were all in agreement that the president, yes, does have immunity under Article 143, as Lavins has rightly put out, but the immunity only extends to constitutional acts. If the president breaches any duty or constitutional, goes or acts unconstitutionally, then the president can be subjected to civil proceedings. So yes, he does have immunity, but it only extends to those acts that he does, to those acts that are constitutional. If he acts unconstitutionally, then immunity is waived. That was the decision in the Court of Appeal.
Thank you.
Is that clear? That's sufficient to, in case you ask such a question on sovereign immunity, take Lavince's and then maybe top it up with the Court of Appeal judgment. Now, Alex, we can go on with Mary, then Waruru, then
So long.
Yes?
Before I have a question to Vincent Noah. Okay, so in regards to murder cases, I think there was a case that was, I think, like there was a judgment that talked about.
Yes, a Kisumu judgment. There was a Kisumu judgment to that effect.
Yeah. So I wanted to ask, like, I thought that case talked about like actually magistrates courts can handle matters to do with murder because it's by them starting by murder cases starting from High Court, it kind of like I think like restrains or limits the appealing other courts.
Yes.
That's right.
Yes, I read that case. It was a judgment that came out in the year 2020. Noah and Lavins will address it. But in brief, that judgment, it's true what you've said. That judgment basically stated that it's unconstitutional to limit the High Court for the jurisdiction to only hear murder cases. Amongst the many reasons they were giving was that it doesn't afford you the right of the proper right of appeal. Let's say, for instance, you were caught with stealing, you have the right to appeal to the High Court. If your judgment, if you're dissatisfied with the judgment of the High Court, you go on ahead and appeal to the Court of Appeal, and even to the Supreme Court if you can prove the matters under Article 163, the general public importance or an issue of constitutional interpretation. But the judgment gave a time frame for the implementation of the same. Was it 10 months? I can't remember very well, but I'll have to check I'll just check it right now while Lavins and Noah giving the comments. The judgment gave a time limitation. It gave a time limit where, it wouldn't be enforced, but then after that time frame or that time period, then issues to do with murder cases can originate from the magistrates' courts. So yes, I recognize there's such a judgment in place. I'll go check it out, then now come up with the appropriate time frame. But it was actually a good jurisprudential judgment. I totally agree with the reasoning. It was a 3-judge bench, and they held that your rights are infringed if the jurisdiction to try murder cases are only placed under the High Court. There are so many reasons. One I've just stated. The other one was that these are old colonial laws that happened that were enacted colonially and all. The other reason was that if robbery with violence, it's also a capital offense, but it's tried in the magistrates' courts. What's so special about murder? But you also need to note that the jurisdiction to try crimes against humanity still stayed with the High Court. And which other crime? Maybe when I get my thoughts, I'll get back to you. Noah and Lavins, maybe you could take it up to expound more on that. Let me try and look for the judgment. It was like a sumo judgment, a 3-judge bench. Let me try and remember a specific name. Google it. And then...
Pops, just make a recap. The person who asked the question, could you just make a recap? I think I was having some connectivity issues. Just repeat what you said, or what you asked with regards to the magistrate courts being given, that authority to handle murder cases. So who asked the question?
Yeah. Mary Waruru.
Okay, proceed.
I asked, since there was that Kisumu judgment which talked about actually address the issue of murder in regards to the right of appeal, because they were saying if a murder case starts from the High Court, then it's kind of like limits your right to appeal, because you only have another, I think, one court or 2 courts to appeal to.
Well, I'd like to read that judgment. Just send it to me. But right now, what I'll tell you is, when was the judgment rendered? This year or?
It was last year, Lavins. It was last year. I've actually gotten the citation. It's Charles Henry Nyaoke.
Okay.
Versus CS. Okay, sorry. Charles Henry Nyaoke was. Let me just put it in the chat box. It's in the chat box. Charles Henry Nyaoke was his Cabinet Secretary, Ministry of Interior and Coordination of National Government, and 4 others. So in case you ask that question, yes, that judgment said that limiting the jurisdiction of murder cases to the High Court is unconstitutional. There were so many provisions that were provided. It was a 3 judgment. It was a very solid judgment that was given. And in that judgment, they gave timelines. Yeah. So, what's the work of the judiciary? It's to interpret laws. They don't enact laws. And that is why they referred it was the first to fifth, let me check. The first, second, third, and fifth respondents. Now, let me name those respondents. The first respondent was the CS, Ministry of Interior. Second respondent, AG. Third respondent, DPP. Fifth respondent, Kenya Law Reform Commission. They were tasked with aligning section 3, 4, and 5 of the Criminal Procedure Code to the Constitution. Yeah? What that basically means is that they were tasked with ensuring or coming up with a framework or amending the existing legislation to provide that murder cases can be tried. The trial court to be the magistrate's courts. That was the decision of the court. And they gave what timeline? 18 months. When was the decision rendered? November last year. Is maybe somebody to just kindly check. Have 18 months lapsed from November last year? Not yet. Yeah. So as of today, murder cases, the court of the first instance court will be the High Court. Now, until the CS, the AG, the Kenya Law Reform Commission come up with a framework and actually not necessarily coming up with a framework, but amend the existing legislations, then the jurisdiction is the High Court. That was the ratio dissidenda in that decision. Charles Henry Nyaoke was the CS, Ministry of Interior and Coordination of National Government. It wasn't like automatically, after we've rendered this decision, murder cases to start in the High Court. No, there was a time frame. The time frame was 18 months to align the decision to take that decision and align the provisions of the CPC with the Constitution.
Okay, so the other question that I have was in regards to adverse possession, like the way Noah said you're supposed to file that matter in the High Court. And looking at the Magistrates Court under Section 9, it talks about like the Magistrates Court can actually handle matters to do with land. Can handle land matters and all that. So like I was asking, like, is it only that because it's an adverse possession, that's why it is you have to like apply to do your application for adverse possession in the High Court, or like what's the reason?
Noah, you want to take that one up? Well, it's an interesting question. There's that decision, Malindi Law Society versus LSK Nairobi branch. Yeah, that decision by the Law Society. Those Mombasa or Mombasa. Yeah, and the issue was, can Employment and Labor Relations Court, can the ELRC, does the ELRC have sole discretion or have the sole jurisdiction to try employment and labor relations matters? Does the ELC, Environment and Land Court Act, also have sole jurisdiction to handle land and environment matters? The question was, do magistrates courts have the jurisdiction to try environment and land matters and to try employment and labor relations court matters? There's that case law. Was it Malindi? But it was an LSK case. Let me try and get the full citation. LSK Nairobi branch, there was Malindi also. But yes, in short, other than Section 9, because in those decisions, what was being tried was that particular Section 9 of the Magistrates Courts Act, which relates to employment, labor relations, land and environment matters. So in that case, the dispute was, can magistrates courts determine land and environment matters? And the answer is yes. The answer is yes. There's a solid there's a solid reasoning behind all that in that judgment. Let me just type it. Yeah, it was Law Society of Kenya Nairobi branch versus Malindi Law Society in 6 hours. They answered in the affirmative. Magistrates courts do have jurisdiction to hear and determine employment and labor relations matters and environment and land court matters. But the primary consideration is they have to be in tune with the pecuniary limits under Section 7 of the Magistrates Courts Act. So yes, they can listen to employment and labor relations matters, but then the jurisdiction is based on the pecuniary limit. So if the subject matter or the value is above 20 million, then automatically that matter goes to the High Court. When I'm talking about the High Court, it's the ELRC or the ELC respectively. If it's below 20 million, then they go to the respective courts based on the pecuniary limits. Now, maybe you could add something on that with regards to now specifically adverse possession, if you have anything to add.
From my understanding of Order 37, if I may, adverse possession. No, I normally read what the Act says. I've not come across any case law, especially with regards to OS being filed in the magistrate's court. So jurisdiction, when you read Section 7 and 38 of the Limitation of Actions Act, it's straightforward, and it says when one wants to obtain a vesting order with regards to adverse possession, then you have to move the High Court. I don't think there's any other provision, unless there's a particular case law, I don't know. I'm always of the opinion that normally land matters, pecuniary jurisdiction, you can go to the chief magistrate. But with regards to specifically adverse possession, you have to go to the High Court. And I've Salonka, many of these matters, they normally go to the High Court. I don't know if you could confirm originating somewhere.
Yeah. I've seen
one for how to enforce an undertaking is the High Court. So I don't know. I've never seen an OS in a magistrate's court.
And then also, I see when you're reading the CPR, you also need to refer, because, okay, I don't have it here, but if you check Order 37, it refers you back to the Limitation of Actions Act, yes?
Yes.
And what does the Limitation of Actions Act? It provides for the High Court, yes?
Yes, Section 37 and 38.
Okay, then maybe in the last that I will say jurisdiction will be in the High Court. It says Section 37. I also go read and familiarize myself with it. Yeah. So that's with regards to adverse possession. But in other matters, environment and land dispute matters, employment and labor relations matters, magistrates courts have the jurisdiction to hear and determine those matters based on the pecuniary limits. The authority is the Law Society, LSK Nairobi branch versus Malindi Law Society, that case law, and also Section 9 of the Magistrates Courts Act. So now, maybe now we can go to Mary.
Yeah, Salonka, before we continue.
If you maybe, okay.
Sorry, yes.
Now I can repeat the second question he gave on adverse possession. I didn't quite get it. The second case. I think it was Wilson Njoroge.
Wilson Njoroge Kamau versus Nganga Musheru Kamau.
Okay, thank you.
Yes.
The first one as well, please. I didn't get the first one.
The first one, it's also an ELC. It's Selina Mudhoni Kidhinji. Selina Mudhoni Kidhinji. On her behalf and 5 others versus Safi Binti, Swale, and 8 others.
Thanks.
So we proceed. Yes, Mary, are you ready? Okay, I know Odur had a question. Another question. Odur, there is something you were saying.
Yeah. Thank you so much for the opportunity. So if you realize what Noah has been saying and the cases that he has been talking about, I think he's saying that they are from the ELC and they regard adverse possession. Then again, related to what Mr. Patrick told us, Lavins, if you look at Article 165(5) of the Constitution, it says that the High Court shall not have jurisdiction in respect of matters. If you look at B, falling within the jurisdiction of the courts contemplated in Article 162(2).
Yes.
So that includes the ELC. I'm of the opinion that adverse possession is a matter that concerns land. And so the High Court cannot listen to that case. And the Constitution is the Supreme Court, the supreme law of this country. So I don't know.
That's very true.
I tend, yeah?
Sorry. When I say High Court, I mean the ELC and the ERRC. It's we weren't talking about High Court exclusively. High Court, maybe, sorry, but since they are courts of equal status, that's why I just name all of them as the High Court. But yes, the ELC and the ERRC respectively, if it's a labor and relations matter.
Yeah, if it's the ELC, then it's fine. Then in relation to the matter as to magistrate courts, I think the court also stated that we have specialized magistrate courts that listen to these matters. So it has to be a specialized magistrate court. Then in relation to employment issues, I think there's the legal notice 6024 of 2018 that said that if there are more than 80, then they can, if you're getting more than 80,000 salary, then you can go to the High Court. But if it's below 80, then you can go to the you can go to the senior resident magistrate court, or you can go to the chief magistrate court. So I think there's also a difference there. But in relation to the adverse possession, when you said High Court, you mean the ELC, then that's okay.
Yeah, that's what I meant. When I was talking about High Court, I was meaning I meant the ELC. And on the issue of special courts, it's those that have been gazetted by the Chief Justice. Practically speaking, it's just similar to all of them. So if you check the provisions of the Act, it's for magistrates courts to be conferred with jurisdiction to hear those matters. Pursuant to the Malindi Law Society and also the reading of the statutes, the Magistrates Courts Act, it's the Chief Justice to gazette the specific magistrates courts to hear and determine those matters. And thank you for that employment and relations legal notice. Thank you for that. I'll go and have a look at it actually. But yes, the ratio decidendi is they have the jurisdiction to hear those matters and determine those matters based on the necessary or established legal pecuniary limits. I've copy-pasted the case laws into the chat box. Okay, now Alex, maybe now you can proceed with Mary. Yes.
Sorry, as much as you're sending the cases into the chat box, could you also send them in WhatsApp? It's easier to refer in WhatsApp later.
Okay, no problem. Let me do that. Let me do that. Okay, I'm sending them in a few. Okay, Mary, Alex, please go on.
Hi, Mary.
Hello, Alex.
I'm fine.
Can
I'm fine, thank you. Yes, I can hear you.
Good.
So I'll ask you a few convincing questions.
Okay.
And then we will discuss later. The first question is, I just have 5 questions. The first question is, can you state 5 laws regulating land which were enacted post 2010?
Okay, post 2010, we have the Land Act. We have the Section of Properties Act. We have the Land Control Act. And then we have the Land Registration Act. And I think I can include the Constitution of Kenya, particularly Articles 60 to, I think, 70.
Okay, thanks. The second question is, Mr. Z, this is a what can I call it? It's like a theory question or a problem question. So Mr. Z borrowed a loan of 2 million shillings from Mapesa Bank. The loan was secured by a charge on Mr. Z's land in favor of the bank, but Mr. Z defaulted on paying the loan. Can you state at least 5 remedies which are provided under the Land Act that are available to the bank? Did you get the question?
Yes, the last part, I didn't get the last part. Maybe you can repeat where I think he defaulted from that part of defaulting.
Okay, Mr. Z borrowed a loan of 2 million from Mapesa Bank, and the bank was secured via a charge on Mr. Z's property. So Mr. Z has defaulted on repaying the loan. What are the 5 remedies provided under the Land Act which are available to the bank?
Okay, so the remedies available to the bank, we have the statutory power of sale. I think we have leasing. Leasing, I think equity of redemption. Okay, and what other one? What other one? Oh God. I think I can remember the 3.
Okay. You can just go to the next question. We'll come back and look at what are the right answers. The third question, it's also a scenario question. So Mr. X borrowed a loan of 5 million and the bank was secured also through a charge on the property of Mr. Z, Mr. X. Let's call him this one Mr. X. So Mr. X has since reneged on payment of the loan. So the bank has decided to sue Mr. X. Which court has jurisdiction over the bank's suit, or in which court should the bank institute its suit?
Okay, which court? Okay, so after now the charge defaulted, yeah?
Yes.
Okay, after the charge defaulted. I would say the ELRC, the ELC court.
Okay. The last question. You know there are LSA conditions of sale 2015. Yes?
Yes, I do.
So are the LSA conditions of sale 2015 binding on parties to a sale agreement for sale of land?
Well, okay, I would say they are not. Okay, the parties to an agreement are free to include whatever clauses they want or conditions they want in their agreement. However, it has to be in accordance with the condition, the LSK conditions of sale. So yeah, I would say they're binding.
Okay, thanks. So long I can ask your questions and then we can.
No problem. Hi, Mary. Kindly give me the 3 main parts of a charge, or the elements of a charge.
Go ahead. Okay. The elements of a charge.
Yes.
Okay, we have the parties, and we have of course the definition and the interpretative part, and the conditions, and of course.
Oh no, sorry, in criminal law. Sorry, I did in criminal litigation. Sorry.
All right, I thought it was convincing.
No,
okay,
no.
We have commencement, statement of offense, and the particulars.
The particulars of offense.
Yeah, particulars of offense.
Okay. What is joinder of persons? Distinguish it from joinder of counts.
Okay. Joinder of person, I would say is enjoining other parties to the suit. And joinder of counts, I think including more charging. I'm not sure about joinder of counts, but I think it's including charges. Yeah.
Okay, no problem. That's fine. Have you learned about have you done administration and insolvency in class?
Yeah, we have.
Okay. What are the objectives of administration?
Okay, the objectives of administration is one, it helps the company to realize its assets or to organize itself before going into now insolvency. And of course, there is the protection from creditors going to court claiming maybe their money is back. Yeah, I would say those two. So the protection, company realizing itself and realizing its assets.
Okay. What are the contents of a judgment, of a criminal court judgment?
Okay. Of course, we have the background, or rather the facts.
Yeah.
We have the issues. We have the ratio. And wait, criminal. Okay, I think it's the same. Ratio and then the orders. That's what I'd say.
Okay, no problem. Thank you. Thank you for that. Now I have 3 questions remaining. Kindly give me kindly list for me at least 5 duties of a director.
Okay, duties of the director. One, we have the duty to promote the success of a company, and then we have duty to act with reasonable care and skill. Then we have duty to avoid conflict of interest. Then we have duty to avoid taking profits or benefits that would compromise the whatever they act as directors of the company. And I think I was acting in good. So yeah.
Okay. List for me at least 4 instances where an originating summons is used.
Okay, an originating one is provided for Order 37, procedure, and one instances of adverse possession, and the other one is extension of time, that is limitation of actions. Then the other one is suit by an administrator or executor, and the other one is say case scenario where we have the vendor and the purchaser settling their dispute, and that dispute should not be concerning the validity of their contract of sale. Yeah, their contract. It should not be about the contract, but any other dispute. And then, of course, we have interpleader.
Okay, now, second last question. Why would I use a notice of motion application to do an application for injunction and not a chamber summons? Why would I use a notice of motion and not a chamber summons to do an application for injunction?
I would say because it's the default.
Yes.
It's the default way of making an application under order 51. Yeah. Yeah.
Thank you. Now, the last question is, when doing or instituting judicial review proceedings, do I need to seek for leave? What's your opinion on that?
Well, for judicial review, there are two ways. You can decide to go the traditional way, or you can decide to go the other way, which is not traditional. The traditional way is where you seek leave, and the traditional way is under order 53, where you have the stage, and then of course you have the substantive stage. Yeah. So the arguments for the leave stage delaying trial, but then on the other hand, we see that the leave stage is where the court is able to assess and see if there is really a case here, and then you can continue to the next stage. So in my perspective, I think the traditional way, in as much as this argument for delay, but the leave stage acts as a sieve to avoid so many cases that would abuse the process of the court. And yeah.
Okay, thank you for that. Thank you for that. Now, last question, sorry for this. I want you in 2 minutes to outline for me the 3 main conveyancing stages. Just expound on the entire conveyancing process in 2 minutes, outlining the main stages in a conveyancing or in a typical conveyancing transaction.
All right. So, conveyancing transaction, we have two parties. We have the vendor and the purchaser, and of course we start with the first stages where the parties approach the advocate, and of course they give the instructions. And case scenario, let's say it's the purchaser. You give the instructions, and then from there, there's the what is it called? The investigation of title stage. Yeah. So the investigation of title, the purchaser will do a search. They also do pre-contract inquiries and the requisition. And then thereafter, after the search and after ascertaining that indeed it's a good title, then that is when they proceed to the signing of the sale agreement. And then on the signing of the sale agreement, it is during that process where we also have the exchange of the deposit. And yeah, and also now after that part, we go to the next part. Now will be to after the sale agreement, we exchange the documents. Yeah. And also the purchaser's advocate can give an undertaking. Yeah. And the undertaking will be that they will pay maybe the balance of the purchase price upon maybe receipt of the completion documents from the vendor. So after now they receive the completion documents, Of course, they will draft a transfer or a conveyance. So on drafting a transfer or a conveyance, of course, they have to send it to the other party to approve. Approval involves also making amendments, and the other party, of course, they will return to now the purchaser, and then the purchaser will engross the same, and then thereafter they have to obtain the stamp duty. So after obtaining the stamp duty, then now they can continue to register. So after now the registration, that is when now the interest in land is transferred. Yeah. So now from the vendor to the purchaser, and now of course the purchaser will have to fulfill their end of the bargain by paying the balance of the purchase price. And if they pay the balance of the purchase price and there was a professional undertaking, then that professional undertaking is released. So yeah, that is a conveyancing transaction.
Thank you so much for that. Thank you so much for that. You did very well. Now I'll give you my feedback after Alex gives you his. Alex, please go on.
Okay, thanks. I think Mary did well. She has tried to. Her approach of the questions has been good. She has tried to answer questions to the best of what she could have done. I think also she is confident. The pace at which she approaches these questions is also good. So with regard to my feedback, with regard to the questions which I had asked, I asked her 5 questions with regard to or mainly on land law. The first question was 5 laws which regulate land after 2010. This question is what can I say? It looks like an easy question, and it's a question which Mr. Ayera, he likes asking this question because it is the easiest question to get you or to get you off guard if you are not careful, especially because it looks simple. It is a simple question, but then when you try to attempt and answer it, you find that it's not that simple. So it's simple, but it's not simple. So 5 laws enacted post 2010 regulating land in Kenya, or regulating land in Kenya, basically. The first, of course, this Land Act, there's Land Registration Act, there is Sectional Properties Act 2020, there is Community Land Act 2015, there is National Land Commission Act. Those are already 5, but they are quite a number. Probably they are around 7 or 8. So you should be careful about such questions which look easy, but when you try to answer them, you realize they are not that easy, especially in an oral setup where you are under pressure. So she mentioned the Land Control Act. The Land Control Act was not enacted post 2010. It's quite it has been there for some time now. Okay, that was the first question. The second question was, this guy called Mr. Z, he borrowed a loan of 2 million from a Pesa bank, and he reneged on paying the loan in accordance with the charge instrument. And I asked 5 remedies which are available to the bank to exercise against Mr. Z. So these are basically remedies of a chargee, which are found under Section 93 of the Land Act. The first remedy available to the bank is to, number 1, sell the land. I mean, you charged this guy's land, this guy has failed to pay. So what do you do? Just attach the land which you secured, sell and recover your money. The second option is you can sue this guy. You got into a contract with this guy to pay you money. You give this guy money, you agreed that he would pay you a principal and interest over a period of time. This guy has basically breached the contract by failing to pay as you had agreed. So if a person breaches a contract, what do? You sue them. Still, you will find it under Section 93 of the Land Act. Another remedy available to a changee is to lease the land. Instead of selling the land, you can lease. Those are three. The first remedy is to get into possession of the land. A changee can kick out the guy who has defaulted and get into the land and stay on the land and utilize the land to get back his money. And finally, the changee can appoint a receiver over the land. Let's say, for example, the guy had planted some maize on that land. The changee has the power to appoint a receiver who will look after the maize, harvest the maize, sell the maize, and use the money to refund the changee. That's another option available. When you look at Section 93 of the Land Act, you will find the remedies available to the changee against a changee. What Mary told me was the steps of charging a land, or the steps which the changee will use when they want to recover their money under Section 90 of the Land Act, which was different. The third question which I asked is that now it was Mr. X. Mr. X borrowed a loan of 5 million from the bank, and he secured that loan with a charge over his land. But then Mr. X also reneged on paying the bank, and the bank has chose to sue this guy. Instead of taking the land or leasing the land or appointing a receiver, the option they have taken is to sue this guy to get back their money. So which is the court with the jurisdiction that Mr. X can be sued in by the bank? You see, I have asked, the reason I asked this question is because of a former discussion which I have had just a few minutes ago with regard to jurisdiction in land matters. The issue of jurisdiction is usually very simple when you look at it, but out here lawyers argue about jurisdiction every day. I mean, whether a court has jurisdiction or not is the first thing you look at when you are served with documents. It's the first thing when you look at before you go to court. It's jurisdiction, of course, as Justice Nyarangi said, is everything. Now, the court with jurisdiction over a dispute arising from a charge is not the ELC. Mary told me it was the ELC. Most people think it is the ELC. The ELC has no jurisdiction when it comes to the issue of failure to pay money advanced to, if the dispute is about failing to pay the money, it's not a dispute about land. You see, the ELC, the Environment and Land Court, has jurisdiction with regards to land matters, disputes arising from land. Things like adverse possession, those will go to ELC. Things like squatters, you go to ELC. Things like things to do with caution, such things. But when it comes to the issue of I charged my land to the bank, I failed to pay the loan, the bank wants to sue me to recover its money, that is a commercial issue. It's not a land issue. And courts have held that when the matter is over, what you look at when you are looking at the jurisdiction, you look at why is the weight? What is the issue in dispute? Uzito iko side gani? Does it lie on the land question, or does it lie on a commercial? Is it a commercial issue? If it's a commercial issue, you go to the Commercial and Tax Division of the High Court. If it's a land issue, you go to the ELC, and I'll send you a judgment. There's a 2021 judgment Kenya Microfinance, Kenya Women Microfinance, in which the judge has addressed that issue very well. And the court said that if you see even this habit which some judges have, where you go to court and then the court finds it has no jurisdiction and it decides to, now let us transfer this matter. You cannot do that. The court has, once it has been determined the court has no jurisdiction, that determination kicks in from when that matter was first filed in court. The court has no power. The court has zero power to transfer that matter because it has no jurisdiction. How can you transfer a matter from your court to another court when you don't have jurisdiction over that matter? The only remedy available to the parties is to withdraw that matter and file it in another court. Or the only thing that the court can do when it determines that it has no jurisdiction is to dismiss that matter. But it cannot transfer that matter from itself to another court. I'll send you that judgment, you'll see how it has been addressed. But key to note is that when it comes to the issue of money, commercial, the ELC has no jurisdiction. My fourth question was on LSK conditions of sale, and I asked her 4 questions. Sorry, I was supposed to ask her 5 questions. The fourth question was LSK conditions of sale, are they binding? Yes, she was right, but the reason she gave was not proper. The LSK conditions of sale 2015 are binding on parties to a sale agreement for a sale of land. But it's not entirely usually the case. When you look at legal notice number 278, I hope you guys have started reading these legal notices. When you look at regulation 48 of those regulations, they say that the LSK conditions 2015 are binding on parties to a sale agreement for the sale of a piece of land, except if the parties have excluded those conditions in the sale agreement. So if you have your sale agreement and you have not mentioned the extent to which the LSK conditions of sale apply, or you have not mentioned them at all, they will apply to a sale agreement. So you should, that's something you should know. Even when you start practicing law, always be careful. So if you want or you don't want the LSK conditions of sale to apply, or you want to limit the extent of the applicability, make sure you address the same in your sale agreement. Finally, the another question I wanted to ask her, which I think it escaped my mind, was what is the status of a lease agreement by parties which is not registered? So let's say, for example, I am getting into a contract with somebody for them to lease to me their land for a period of 5 years. So we sit down, we prepare a lease agreement, but then we fail to register that agreement. What is the effect of that lease? The effect of such a lease is that it operates as a contract. When you look at, I think, section 36(2) of the Land Registration Act, if you fail to register an instrument, it does not void that transaction, but that transaction will be taken to be a contract. So I hope, so that's the end of my comments. I hope it has benefited Mary and it has benefited every other person who is in this forum. Thanks.
Thank you so much, Alex, for that. Thank you so much for that. Now time is going, and Noah and Patrick need to at least ask a fellow student. So thank you for that. Thank you for that, Alex. So I'll try and rush. Now, with regards to joinder of persons and joinder of counts, that was the first question I asked Mary. The relevant statutory provisions for that is section 136 and section 135, respectively, of the Criminal Procedure Code. 136 is on joinder of persons, and then 135 is on joinder of counts. Now, when we talk about joinder of persons, joinder basically means joining, having 2 or more persons, joining them. So when we talk about joinder of persons, it's joining 2 or more accused persons on the same charge sheet. Okay. So you can join two or more persons. So you have one charge sheet where there's one accused, two accused, there's second accused, there's third accused, fourth accused. But there's a catch if you read section 136. They have to be offenses that have been committed within the same transaction and so forth. Or maybe somebody aided or abetted in that offense, then you join them in that same charge. So I've only given two scenarios. There are like 4, 5, or 6 scenarios which you will find. So sorry for that. Apologies. I got cut out of the meeting. Sorry for that. So yeah, I was talking about joint of persons. So you can go and read the others because of time. But that's joint of persons basically means joining or two or more persons on the same charge. When you talk about joint of counts, this is where you have one or more offenses in the same charge. So for instance, you can have robbery, handling stolen goods. So count 1, robbery with violence. Count 2, handling stolen goods, and so forth. That's joint of counts. Having two or more offenses in the same charge. I'm seeing somebody asking a question on the elements or the contents of a charge. She answered that one very well. And there are 3 main elements of a charge. The first one is the commencement. Now, the commencement is basically the beginning. The beginning, when you look at a charge sheet. This is where you have the name of the accused, the court case number, the police case number, the nationality, the accused person's nationality, etc., etc. If you have a look at the charge, this is the commencement. This is the beginning where you have the name of the accused, the court case number, police case number, the gender, and also the nationality. The other bit is the statement of offense. Now, under the statement of offense, this is where you see, for instance, an example: theft, contrary to section 268(1), as read together with section 282 of the Penal Code, cap 63 of the laws of Kenya. It's a specific provision of the Penal Code or the offense that has been breached. That is where you talk about the section of the statute and the statute itself. So for instance, if it's theft, you say theft contrary to section 268(1), as read together with section 282 of the Penal Code, cap 63 of the laws of Kenya. So in brief, that is what a statement of offense contains. Okay. This is the section that establishes the offense and the section that prescribes punishment. You have 2 things in the statement of offense: the section that establishes the offense, 268(1), and the section that prescribes punishment, 282 of the Penal Code. Okay. Now, the last part, or the last element of a charge is the particulars of offense. So we've talked about the commencement, we've talked about the statement of offense. The last bit is the particulars of a charge. The particulars of a charge basically contains 4 main things: the who, the when, the where, and the what. The the who, the when, the where, and the what. So you have to include, when you're told to draft a charge sheet, the name of the accused person, the time, and the place, and what that person has been accused of. Okay, the name, the time, the place, and what the person has been accused of. So there's a friend of mine who was asked to draft a charge sheet during the oral exams. He was told to just a charge or a charge sheet. So you have to clearly put these things into perspective. So for instance, in the particulars of offense, you can have Alex Baya on 14th February 2021 at Kiserian Township, Kajiado County, unlawfully and with malice aforethought caused the death of P of something. So when you're talking about the particulars of an offense, you have to clearly put out the who, the when, yeah, the where, and the what. And that's everything to do with charge. So joinder of persons, section 136, joinder of counts, section 135. When you talk about duplicity, you're talking about a circumstance where there is more than one offense in one count. More than one offense in one count. So you cannot have, for instance, on the same count, you charge somebody with robbery with violence, and then also charge him with handling stolen goods in the same count. The charge will be defective for being duplicity. There's more than one offense in one count. The rule is one offense, one count. One offense, one count. If you have more than one offense in one count, that is where you talk about duplex charges, duplicity. It has more than one offense on the same count. Now, moving forward, I asked the objectives of administration. The objectives of administration are found under section 522 of the Insolvency Act. You can go check it out and maybe look at various case laws. There is a Avid Engineering by Justice Stewart. Check out that case, and also section 522. The core objective of administration is to maintain the company as a going concern, not to liquidate the company. You're not going to wind up the assets. You're going to maintain the company as a going concern so as to achieve a better outcome than if it was liquidated. So when you talk about administration, you don't go and start selling the assets of the company straight up. You maintain the company as a going concern, meaning you're running the company, the administrator is running the company, so as to ensure that a profitable outcome comes in and to ensure that the creditors are paid up. So that's the objective of administration. Go check section 522 of the Insolvency Act. It talks about maintaining it as a going concern and various others. The other question I asked was the contents of a criminal law judgment. So you are right. You are right with how you analyzed it. So I am hearing an echo. Okay, let me go on. So when you talk about the contents in a criminal law judgment, if you don't have a specific answer maybe for that, you just talk generally of how a judgment or what a judgment should include. But when you talk about a criminal court giving its judgment, there are certain things that ought to be there. The name of the accused has to be there. The charge that the accused person has been charged with has to be there also. You need to talk about the summary of the evidence that has been adduced by the prosecution and the defense. There has to be the evidence that has been adduced, the points for determination, the decision made on each point, the reason or the rationale for each decision. And then in case of a conviction, specify the offense and the relevant section the person is convicted with or convicted of, and the punishment imposed for each count. And then if the person has been acquitted, you should also state the offense acquitted from and have an express order to set aside, not to set aside, but to set the accused at liberty. So that's the contents of a criminal law or a criminal court judgment. The name of the accused person, the charge, the summary of the evidence, the points for determination, the decision for each point, the rationale and the ratio decidendi or the reasoning behind each point. And if there's a conviction, you need to specify the offense and the relevant section. And then if there's an acquittal, an order setting the accused person at liberty. Now, because of time, duties of a director, we once went through it. So there's no need to repeat. She got all of them correctly. Check the Companies Act, starting from section 142. Just read from section 142 going downwards. Now, the issue of, for instances, where an originating summons is used, she also got it perfectly right. Just go read section order 37 of the Civil Procedure Rules. It contains a list of where you use an OS. Yeah, there's order 37. There's also order 34 on interpleader. In interpleader proceedings, so if you're bringing interpleader proceedings as a fresh suit, you institute an OS. There is also adverse possession. She talked about contractual dispute for a sale of land, but there's a catch. That dispute should not be on whether the contract exists or doesn't exist. It should that's the catch. So it's any question to do with the purchase or to do with the sale and purchase of land, but the question should not be on the existence or whether that contract of sale existed or didn't exist. There are various other other instances where you use an originating summons. So just check order 37, check order 34 of the civil procedure rules, and you'll find at least five. Now, on the issue of notice of motion and chamber summons, we went through these a few weeks ago. The main difference is you use a chamber summons where it's expressly provided for by the rules or by the statute. So if you check order 1, for instance, order 1 is on parties to a suit. It provides clearly that when you want to, to add a party, when you want to institute that party proceedings, when you want to seek leave for that party proceedings, when you want to substitute a party, when you want to, remove a party and so forth, you do it by way of chamber summons. Okay, it's expressly provided for under the rules, the civil procedure rules. However, a notice of motion is the default application, and it's a default application pursuant to order 51 of the civil procedure rules. So if you encounter a situation in the civil procedure rules and it doesn't provide for whether you use a notice of motion, or whether you use a chamber summons, like it's silent on which application you draft, you move the court by way of a notice of motion by virtue of order 51. But if it's expressly or clearly stated in the civil procedure rules, you will go on ahead and use the chamber summons application. We did this in the, I think, past in the previous 2 sessions, the oral sessions. Now, to sum up, a typical conveyancing transaction. I remember I promised you that we will do an overview of the conveyancing process, but I don't think time will allow us today. So maybe we can, because I need to give my colleagues Lavince and Noah to question. We can do it next week. But in brief, a conveyancing transaction has, if I can put it correctly, 3 main stages. And this is how conveyancing is actually very simple. You have the pre-contract. That's the initial stages, the pre-contract, stage 1. You have the contract stage 2. And then stage 3, you have completion. And then maybe we can add the 4th stage to be registration. Okay, so there are 3 main stages: pre-contract, contract, completion, and then registration. Okay, when I talk about pre-contract, everything before the contract is signed falls under pre-contract. For instance, investigation to title. How do you investigate title to land? Because if you approach, if a purchaser comes to you as an advocate, if a purchaser comes to you as an advocate, he wants you to act for him on behalf of a transaction. He wants to buy 100 acres of land in a place known as XXX. So, as an advocate, you have the duty to conduct a due diligence to investigate the title to ensure that the 100 acres this person is buying is free from encumbrances, is free from, it's free property, that, the vendor is the proprietor, he is the person with the valid title, so he can dispose of the property by selling to the purchaser. So how do you do investigation to title? We did this a few weeks ago. Searches is one of the main ways of doing investigation to title. The other thing you can do is pre-contract inquiries, and the other one is requisitions. Okay, so when you're investigating title, searches, pre-contract inquiries, and requisitions. There are 3 ways of investigating title: searches, pre-contract inquiries, and requisitions. Under searches, it can be broken down further. And these are common. If you meet a error in the oral panel, this is a very common question. Conveyancing, because it focuses on conveyancing. A search, how can you do a search? The first one, you can do an official search. An official search is conducted in the relevant land registry. So if the land is found in Kajiado, you will go to the Kajiado Lands Registry and then apply for a search, and then you'll be given a certificate of official search. Okay, that's an official search. You go to the relevant land registry, make an application, and you'll be given a certificate of official search. Now, Another type of search you can do is a personal search. The personal search is you go to the lands registry and you're the advocate now. The advocate goes to the lands registry and you peruse the title of the documents relating to the title. So you look at the documents. The advocate himself goes to the lands registry and he looks at the documents to ensure that the title is valid. You can also do a historic search. A historic search, you've heard of the Ndungu Land Report. So you need to look at the root. You need to look at the root and history of the title to this property. What's the reason for this? You can find a particular piece of land is listed in the Ndungu Land Report. If it's listed there, problems may arise in future. For instance, what if the government says, you know, this land is public land and your client has already bought this land? So those are the three types of searches you can do, the main searches. The other relevant searches you can do is at the county government. You can go to the county government to check on issues to do with change of users and so forth. You can also go to the survey department. You can go to the company's registry. That forms part of investigating title and due diligence. Pre-contract inquiries, this is now we've talked about searches. Pre-contract inquiries is where you go and physically assess the condition of the property. Why do you physically assess the condition of the property? To go and determine any patent defects in the property. So it's part of due diligence, provides that don't rely on the search because the searches don't have full and accurate information. So what you need to do is go look at the land, the physical conditions of the land, look at the neighbors who are those living next to your land, what are the development prospects and planning permissions with regards to that property, and so forth. That's all to do with pre-contract inquiries. Now, requisitions is another way of investigating title, but it doesn't come at the initial stages of investigating title. It usually comes up after the contractual stage. But that's the first stage we've talked about, pre-contract. It mainly deals with those preliminary matters. The advocate walks into your office, client interview, investigating title, and so forth. The second stage is the contractual stage. And the contractual stage basically just entails the process of entering into the sale agreement, the contract. Okay. So who prepares a sale agreement? This is a commonly asked question by IERA. You need to know who prepares a sale agreement, who prepares a charge document. And so he usually likes to ask those questions. The person who prepares a sale agreement is the vendor's advocate. The vendor's advocate is the one who is tasked with preparing a sale agreement. Okay, so question will be, go check the law society conditions of sale to check the parts and the various essentials, valid sale agreement. Check the laws. It's something pretty straightforward. And you're done with the contract stage. This is where you enter into the contract. There are some activities that I've left out, but we'll do it another time. But that's where you enter into the sale agreement. Now, in between the contract stage and the other stage which I mentioned, the third stage, which is the completion stage, there's something known as pre-completion stage. Yeah, pre-completion stage. So before completion, there are certain things that happen. The first thing will be the issue to do with deducing of title. So within 14 days after executing the sale agreement, the vendor is usually given an abstract of title. Yeah? An abstract of title. What is the essence of this abstract of title? It's for purposes of deducing the title. So deducing, how can I put it? You're just checking the title documents to see if there are any problems with it. Yeah. So for instance, you've been given the abstract of title, and the person who's selling it to you, the name doesn't appear on the title documents. Yeah. Yes, who's calling? Who's talking? Who's? Oh, sorry. So yeah, that's deducing. Deducing. You're looking at the title documents to determine, are there any problems relating to this specific title? Now, if there are, that is where we come into requisitions. We talk about requisitions. So requisitions are basically questions that arise after you've deduced title. So if there are any questions that you've seen arise or something that you need to raise with the title documents, you do so by way of requisition. The provision for this is under the Law Society Conditions of Sale. Go check Condition 6 and you'll find everything to do with these aspects. So that's it to do with the stage in between deducing title and requisitions. So also in between, there is an aspect of before now the completion stage, who applies for the completion documents. There's also the aspect of the purchaser being allowed to go visit the land. Now, when he visits the land, he needs to check, are there beacons in this piece of property? If there are no beacons, what happens? He can talk to the vendor to put the beacons. If he doesn't, the purchaser can do it and then maybe deduct the sum in the sale agreement and so forth. All those are found under the Law Society conditions of sale. So after that is done, after you've entered into the contract, the pre-completion stuff have happened, completion documents have been applied for, this person has gotten the purchase price and those nitty-gritties have happened. The stage the next stage will be the completion stage. Now, at the completion stage, it usually takes place in the vendor's advocate's office pursuant to the LSK conditions of sale. And what happens at the completion stage is the payment. The purchaser has a duty during the completion stage, and the vendor also has a duty during the completion stage. So the vendor needs to give out the completion document. So initially, during the pre-completion stage, what did he do? He applied for the completion documents so as to get them. Now, he has to give them to the purchaser. So the duty of the purchaser is usually paying the balance of the purchase price. Now, I need you to note one thing. I've watered down this thing so as to finish up the process, but there are so many things that need to be covered in between. So the completion stage is usually found under the LSK conditions, condition 8 to be specific. I won't repeat what the completion documents are. Noah talked about it, Noah Lavins, a few minutes ago. So the purchaser gives the completion documents. This is another tested question in orals. What are the completion documents? List certain completion documents. You need to at least know 5. Kama ukumbuki, there are these basic ones, a copy of the ID, a copy of this, a copy of the PIN certificate, and so forth. You can put those ones there, passport photos, if you don't remember. But there are basic things that you need to know when it comes to completion documents. Certificate of title, various consents if need be, utility bills, the transfer documents in triplicate. You insert the PINs, ID, tax PIN, copy of valuation of stamp duty, and so forth. That's what happens in the completion stage. So once the completion documents have been handed, the purchaser has a duty to pay the balance of the purchase price. Now, he can either pay the balance of the purchase price or have a professional undertaking. Now, this is where undertakings arise. So he can say, okay, there can be an undertaking can be issued by the purchaser's advocates that once the title has been registered in their name, they will release the funds to the vendors. Yeah. Or they can also be the financiers advocates who will state that or give an undertaking that once the transfer instrument has been registered and a certificate title has come out, we will release the balance of the purchase price to who? To the vendor's advocate. Now, when the financiers advocate comes into place, you need to know that there's a security that has to be there, and the security is in the form of a charge. So the financier will also register a charge in that document, or will also register a charge over that title, and also the title documents will be registered in the name of the purchaser together with a charge over that property to secure the financier's interest. Once that happens, then he releases the net funds to who? To the vendor. Now that's it to do with completion. It's as simple as that. Then you move to the last stage, which is registration. So at registration, what happens? In 2 words, valuation. The documents need to be valued, stamp duty needs to be paid, and after stamp duty needs to be paid, they're presented to the lands registrar, who does what? Who registers the title in the name of the purchaser. So the questions that arise here: stamp duty. How much is it? So stamp duty for transfers, it's 4% for land within municipalities, 2% for land outside municipalities. Another question that is asked: what is the stamp duty chargeable, payable on a charge? It's 0.1% for a charge, and then 0.05% for what? For a discharge. Those are some of the small questions that arise in such a circumstance when we talk about stamp duty and all. And finally, that's it. Actually, that's conveyancing. Everything we've talked about, that's conveyancing from start to end. That's it to do with conveyancing. Now, in between, there are things that arise, restrictions, cautions, and all those. I usually call them branches to conveyancing. They don't form part of the main conveyancing transaction, but they are an integral process in the conveyancing transaction, which you will learn about. So yeah, it took so much time, but we had promised, and I had asked that question. But in brief, what I've just talked about is the entire is a typical conveyancing transaction in what? In 4 stages. So when you ask such a question, and this happens, this will apply to those who are asked. If you go to an oral panel and the lecturer is a conveyancing lecturer, just summarize it in 4 points. Remember, you have 10 minutes. If they ask you to talk about anything to do with conveyancing, at least outline it in these 4 main stages: the pre-contract stage, the contract stage, the completion stage, and the registration. Yeah. Having that logical flow, this lecturer will know that this person knows his stuff. So with that, I'll yield the floor to Noah. I'm sorry it took up so much time, but maybe we could extend with maybe 10-15 minutes. There's somebody who requested me to ask, they wanted to be asked questions, and I'll give Lavins and Noah the opportunity to do so. So Mary, I hope that was helpful, and yeah.
Yeah, thank you, Lonka and Alex.
You did very well. Now, Alex and who? Alex and not Alex, sorry, Lavins and Noah. If there's any last volunteer.
There is one question you've not addressed.
Which one?
The JR. There was a question on JR.
Okay. Now the question on JR, it's it's as simple as right now, JR, I can say we have a 3-track system. We have JRs under Article 23 of the Constitution, under Article 22 and 23 of the Constitution. Under Article, kindly mute. So we have JRs under Article 23 and Article 23 of the Constitution, where you can do it in the form of a petition. So you institute a constitutional petition, and one of the orders that you will be seeking for under Article 23 will be an order of JR. An order of maybe certiorari, mandamus, prohibition, and so forth. That's the 1-track system. Under that one, there's no such thing as leave. Okay. Then we have JR under the Law Reform Act and JR under Order 53 of the Civil Procedure Rules. If you institute JR proceedings under the Law Reform Act and under Order 53 of the Civil Procedure Rules, then you need to seek leave of the court before you institute the JR. So which documents are prepared when you're talking about JR or under the Law Reform Act and under Order 53 of the Civil Procedure Rules? You will do a certificate of urgency, you will do a chamber summons application, you will do a verifying affidavit, you will do a statutory statement. That is for the leave stage. For the substantive stage, we just do an originating notice of motion. Okay. The case for this is, you remember the Kiprono case, the one that I sent to the group a few days ago. Take out that case. It explains JR, the judicial review very well, and it talks about this system. It never did away with the leave stage. What they did is they talked about the we have a 2-track system. We have JRs under the Law Reform Act and under Order 53 of the Civil Procedure Rules. And now the last one, where you don't need to seek leave in any manner whatsoever, is judicial review instituted under the Fair Administrative Actions Act, FAA. If you institute JR under the FAA, pursuant to the case laws, there's one by Justice Nyanmoya I posted to you a few days ago. There is no need to seek leave, and I have seen case laws which have been instituted. You just file an originating notice of motion. Once you file it, that's sufficient. There's no need to seek leave. That's because they moved the court under the Fair Administrative Actions Act. Hence, no need for seeking leave to institute or to institute judicial review proceedings. But if you do it under the Law Reform Act, or if you cite Order 53 in your application for JR, you will need to seek for leave. Okay, that's the difference when you talk about leave stage when it comes to JR. I can say in my own jurisprudential my jurisprudential arguments is we have a 3-track system. Under petitions, under Article 23, we have the Law Reform Act, and under 53 of the Civil Procedure Rules, because they haven't been amended yet. The Felix Kiprono case said, okay, yes, there may be some aspect of, the FAA was intended to amend the Law Reform Act, but as it stands right now, it hasn't been amended, meaning it's still in force. So if you do it under the Law Reform Act and under the Civil Procedure Rules, then you need to seek leave of the court. But if you move the court under the Fair Administrative Actions Act, which was enacted pursuant to Article 47 of the Constitution, then there is no need for you to seek leave of the court. What's the difference between the three of them? Sorry, I took up much time.
Sorry, Solanka, before you proceed, can I ask a question?
Yes, please go on.
It's on the completion documents that you were talking about. You've mentioned that the vendor's advocate is the one who goes to the relevant authorities to get them, but one of the completion documents is the transfer. So according to the LSK conditions, it first says what you said, that it's the vendor's advocate who goes to apply for them in the relevant authorities, but then it also says that the purchaser's advocate prepares them or something like that. So I was just wondering, what is this transfer instrument, and is it prepared by an advocate or is it gotten from an authority? And if so, who does that? Is it the purchaser's advocate or is the vendor's advocate?
Thank you for that. Thank you for that. And when I finish this, maybe Alex or Lavinson Noah can jump into it. So there's this bit. If you read the Law Society conditions of sale, you will need to check the Law Society. Actually, they've summarized this entire process. There's an aspect known as the pre-completion formalities. There's a pre-completion formalities. So if you check the LSK completion conditions of sale, condition 7 is pre-completion, 8 is completion stage. The purchaser's advocate does a draft transfer. Yeah. So the purchaser's advocate will prepare a draft transfer. So remember, this is a draft. Then send it to the vendor's advocate to approve. Okay. Once he sends it to the vendor's advocate to approve, during the completion stage, it's the vendor now to give a duly approved transfer. That's the long answer short to it. And when you talk about, when you check the LSK conditions of sale, the vendor's advocate applies for the completion documents, but it also provides that there's a bit where it provides that, for instance, when it comes to consents and all, the purchaser's advocate should assist in attaining those documents. But in the aspect of transfer, the purchaser's advocate, during the pre-completion stage, pre-completion before completion, will prepare a draft transfer, send it to the vendor's advocate to approve. Now, during the completion stage, the vendor's advocate will now release this approved transfer document. So a transfer is basically an instrument under legal notice number 278 of 2017. Is that sufficient?
Yes.
Okay. So is there anybody, or are you guys tired, who wants to be asked a question? There was someone, maybe I can give my colleagues Lavins and Noah, maybe Alex. I'm sorry it took up much time explaining the conveyancing transaction, but guys really asked me to do it over the week. That's why. So maybe Lavins and Noah can give something for the remarks. Yes, Wanyama?
Can be asked questions if they're still up for it, that is.
Yes, Lavins and Noah, please go on.
Noah, you can take it up for Wanyama, and then I'm seeing two hands. There's one for Nyabir, Diana. So I think I'll wrap it up with Diana. So Noah, you will take up Wanyama's hand and present your questions.
Okay, Ms. Veronica, good evening.
Good evening, Mr. Noah. Nice to hear from you again.
Nice to hear from you too. So my first question is, what is that?
What is?
Trust under a commercial agreement.
I am not very sure, but I'll try an attempt from what I think I will answer. Basically, under a commercial agreement, we find that, for example, under PSR, we find that there are pledges and we find there are financial leases. So I find that this major transaction between the financier and the person who is being loaned the money, that kind of transaction is what I will term as trust, though I'm not really very sure, honestly.
Fair enough. My second question is, when have you done insolvency?
Yes, we have.
When is one adjudged bankrupt?
Right. So one thing we have to note about bankruptcy and insolvency to start with is that bankruptcy applies to a natural person and insolvency applies to a legal person. So when a person is adjudged bankrupt, it means this person is unable to offset their debts, and the Act provides for debts up to 100,000 shillings, I think. Yeah, and then they are, I will say when a person is unable to pay their debts of at least 100,000 shillings. So there are several people who can be adjudged bankrupt. And it is interesting that I found out that an infant can actually be adjudged bankrupt when this infant transacted something for necessities, infants and children, and then also the mentally incapacitated person can be adjudged bankrupt if they got into bankruptcy or transactions that got them into bankruptcy during their lucid moments.
Okay. Give me 3 registers under the Companies Act. 3 registers under the Companies Act.
All right. So under the Companies Act, I will say first the company register. All right. Let me pass.
Okay. I understand. Happens. And then lastly, last week you attended the orals, yeah? And I talked about something to do with advocates, Lian. You remember?
About advocates?
Lian.
Sorry, advocates what?
Advocates, Lian.
Advocate, yeah, Lian.
Yes. So basically, an advocate's lien is, a lien is basically a right to retain. These are rights granted to lawyers to retain a client's property, which they normally have. They can even be title deeds so that that particular client pays. India. So my question is, what are the disadvantages of using this means of recovering money? The arguments against the advocate's lien, if you can think of any. That will be my last question for you.
Thank you. As you've described an advocate's lien, then therefore the disadvantages that arise is what if the property of the client or the property of this person will not be able to offset the outstanding debt, one. Secondly, what if this person, this party is bankrupt, for example, if it was a bankruptcy proceeding. And then the third disadvantage that I will think of is that a lien provides an advocate with the responsibility of auctioning out this property, which is another responsibility altogether that an advocate wouldn't want to undertake or didn't foresee undertaking when they were taking a client. So maybe that is also another disadvantage, an added responsibility on top of what they have already done.
Okay, thank you. Because of time, I will not ask any question. Lavins, are you going to ask her or you have another person in line?
I'll just ask Diana. So just give Wanyama your response, and then I'll wrap it up with Diana.
Okay. My first question was the issue of a trust. I'm sorry, maybe you have not been taught. So, in a nutshell, a trust is basically a relationship, a legal relationship between one who creates it, the trustee, and beneficiary. So the creator is always known as the settlor. When you have been asked issues to do with trust, terminologies are very important. So it's a relationship between a settlor, a trustee, and a beneficiary. So what happens is that the person creating the trust, the settlor, transfers their ownership of their assets to the trustee, who in turn holds it for the benefit of the beneficiary. Normally, when you look at your news, normally these prominent former politicians, the old ones, they normally use trust as a means of transferring legal ownership. For instance, normally, I don't know what attracts them to KCB Bank. You find that a politician, by way of trust, transfer legal ownership to the bank, who in turn hold it for the benefit of the beneficiary. So the beauty about this is that normally there is a smooth transfer of assets by avoiding costs that would have been associated with the normal succession process. So it's always encouraged. If you want to avoid using the normal wills, you can do trust when transferring ownership. Another thing is that there's some form of, a significant level of protection that is afforded to the beneficiary. Since that particular ownership, given that it is being held by the trustees are normally bound by that particular trust. So any trust relationship, the bank or the trustee, or rather the trustee, they're normally bound by it. They cannot go outside that particular arrangement. Then the beauty about it, it's also flexible. Trustees are allowed, to invest in those assets that are in their possession. So that's an overview. Because of time, I cannot go further. Then the second question I asked about when is a person adjudged bankrupt. So it's a very simple question. I expected a one-line answer. A person is adjudged bankrupt when the court adjudges him. So whenever a court makes a bankruptcy order, then that particular person is adjudged bankrupt. It's not an issue of whether he has paid, is unable to pay, So the moment that court makes that order, stating that he's unable to pay debt, and Veronica, I'll advise you to go and read section 13 of the Insolvency Act. So the circumstances are that in order for the court to adjudge somebody bankrupt or issue a bankruptcy order, they must demonstrate that this debtor is unable to pay his debt when they become due. So what the court normally checks is the court normally checks, I think, certain components before issuing a bankruptcy order. So one, the court will have to check the ratio of the assets and liabilities of that particular debtor. Number two, the court will ask itself, does that particular debtor have reasonable prospects of paying that debt? And then lastly, what the court checks also before looking at or issuing that order is the value of the debtor's estate. So those are some of the factors that the court normally considers. Then I asked another question. What question did I ask again? Kindly remind me. Ms. Veronica?
Yeah, you asked about, no, you've already talked about the insolvency. Let me gather.
Yeah.
You've talked about insolvency.
I think the advocate's Lilian, eh? So the arguments against it's lien. So when it comes to lien, lien is basically a way of enforcing fee agreements where you realize that a client has refused to pay. So you hold those particular important documents, for instance, title deeds, until that particular client pays. Now, it was an open-ended question, and I agree with you. For me, my reasoning would be some of the arguments against lien is there are other means of enforcing. The other means being doing a fee note. You do a fee note to the client, and then if you refuse to pay, you do an advocate client bill of cost. So it's a bit more appropriate as opposed to holding the client's money until he pays. Then there's also an issue where a lien can also enforce an advocate's right to damage his client's cause. For instance, there's always this practice by advocates that usipomlipa anaacha case katikati. So I think it's also a problem with advocates. They normally take up a matter, then whenever a client is not able to pay for some reason, we hear they leave that matter in the middle during the course of the proceeding. So it's also a bad thing. And then I agree with you. There are certain documents unaweza hold, but they cannot remedy that situation. They are of lesser value. So I agree with you totally. And that will mark the end of my response to the question, my question, sorry.
Thank you so much, Noah. Thank you so much. Apologies, today I'm very tired. I don't even know what I was answering.
It's okay, it's okay.
Diana, are you ready? Thank you, Noah. Diana? Diana, you can unmute, please. Is she in? Because I can see her hand is raised.
Actually, Diana was the one who told me she wanted to. I don't know. Diana, are you in?
She's been raising her hand, so is she in or she's not in? Right, so unless there is anyone who'd like to volunteer, the last person for today, and we can wrap this up. Right, I can see Manyara. Yes, please. So you're the last person for today.
Yes, good evening. I hope I can be heard.
Can you hear me?
Yes, I can hear you. Can you hear me as well?
Yes, thanks.
Sure. Kick it away.
Okay. So I'd like you to just I'll ask 3 questions for the sake of time. So the first question is, could you just give me 3 instances when directors of a company become liable to third parties?
Yes. Okay. Let's cosplay as if we're in the orals. Thank you, Senior, for that question. So the 3 instances where directors of a company are liable to the shareholders are where they act ultra vires. This means they act contrary to what is provided for in the Articles of Association. Yeah, that is the first instance. The second instance would be an instance where they have committed fraud or any form of fraudulent misrepresentation. And the third one would be where they fail to where they where they act contrary to their mandate. that let's say, for instance, they abuse their voting rights that are provided for under the Companies Act of 2015. Yeah, thank you, my senior.
All right, thank you. My second last question, what is judicial notice?
Oh, thank you, senior, for that question. Judicial notice is where the judicial notice is provided for under section judicial notice is where the court takes notice of okay, Lavins, it's a certain section in a certain provision. Nimesahau akimaze.
That's okay. That's okay. Yeah.
It's not funny.
Yeah, I understand. It happens, so don't worry. I'll respond. So my last question: what is nolle prosequi?
Thank you so much, senior, for that question. So nolle prosequi is yeah, this is the power of the prosecution to terminate its proceeding where the case has not yet been, where the prosecution's case has not yet been heard. This instance of nolle prosequi arises in the instance where in a circumstance where the prosecution deems the case to be of no merit and thus terminates the proceedings. In such an instance, senior, the prosecution, the accused person shall be acquitted by virtue of nolle prosequi. Thank you, senior, for this opportunity.
Just a follow-up of that particular question that I've asked you. Perhaps just tell me the two modes of entering a nolle prosequi under the CPC. Just the two modes of entering a nolle prosequi under the CPC.
Yes, thank you, senior, for that question. Nolle prosequi may be entered by way of Section 87 of the Criminal Procedure Code. Also, there is the provision of Section 203. Okay, Lovins, mazi hapo nimekubullshitted. I know I've bullshitted you.
Right. So just to give a quick response, I think I'll begin with what is that? The first question.
Judicial notice.
No, the directors. So when do directors of a company become liable to third parties? One, when they engage, when you say ultra vires, you have to break it down. Ultra vires is quite a blanket statement. So the one is when they engage in illegal contracts. Two, yes, ultra vires could apply, but you could bring it perhaps at the last end. The other instance is when they engage in business, which is actually not an objective of this particular company. So you'd find that if they deviate from the main objectives of the company, then they'll be liable to the third parties because their actions are not in tandem with the articles of association. So the second question that I asked you is about judicial notice. So it is defined, as the liberty accorded to a judicial officer to recognize the existence or non-existence of certain facts or phenomena, without calling for evidence. So the effects of judicial notice are enshrined, under Section 59 of the Evidence Act. That is to mean no fact of which the court itself shall take judicial notice need be proved. So therefore, judicial notice dispenses with proof. So the basis of judicial notice is that of matters that are actually known by everybody. For example, the judges will know that if you imbibe certain liquids, you can get intoxicated, or the fact that a man has two legs. This is commonly known and will simply not need evidence to prove. So any attempt at adducing evidence for such matter will waste the court's time. So that's why we say the court always take judicial notice on matter that is prima facie, enough evidence to be dispensed with, okay? Then the last question I asked you now about the nolle prosequi. So the nolle prosequi is a statement, that the government intends to discontinue the proceedings in the court of law. So when you look at section 82 of the CPC, Cap 75, it is always entered by the DPP at any stage of the proceedings before the verdict or the judgment. And then the follow-up question that I asked you on this, the two modes of entering a nolle prosequi under the CPC. One, we have the DPP, may state it in court, or the other mode is the DPP may actually inform the court in writing that a nolle prosequi has been entered, and that is pursuant to section 82 subsection 1 of the CPC. So once a nolle prosequi is entered, it stays the proceedings in respect of which it was entered sine die, okay? And then the other instance, it discharges, the accused person, or if, he or she has been committed to prison, he has to be released. Or lastly, if on bail, his recognizance, shall be discharged. I talked about the difference between a bail, a surety and a recognizance. I once asked somebody here. And then if an accused is not before the court when a nolle prosequi is entered, the registrar or clerk of the court shall forthwith cause notice in writing of the entry of the nolle prosequi to be given to the keeper of the prison in which the accused is detained. And then the power is exclusively vested in and exercisable by the DPP unless he delegates, it in writing. There's this Latin term called delegatus non potest delegare. The person to whom an action or power has been delegated cannot delegate further unless with the consent of the parent, delegator. So pursuant to section 83, to his senior subordinates, the Solicitor General of the DPP, the Assistant Deputy Public Prosecutor, or even a state council may act on it. And then lastly, when an accused is discharged following the entry of nolle prosequi, such discharge is actually no bar to subsequent proceedings on account of the same facts. So yeah, with that, I think I'm done. And thank you for volunteering. And yeah, looking forward to more of this. So yeah, thank you guys. And
thank you so much, Lavin.
Awesome. All the best. Keep reading. Keep sharpening the iron. Keep praying, and keep being you. So back to you in studio, Solonga.
Thank you so much. Thank you so much. I really thank you, Lavins. Thank you, Noah. Thank you, Alex, for attending. Like I really appreciate it. I appreciate it. You took time, and yeah, it will pay off one day in the end. So thank you so much. Okay, David, we'll ask a question, then now we can close.
Yeah, only a reminder on this, the 3 registers, a question asked by Noah. He didn't answer about the 3 registers under the Companies Act. Thank you so much for an interactive session.
So the company registers, those registers that are normally kept pursuant to the Company Act. So first we have the register of members. I'll just list them. We have the register of members, that is section 93. Then we have register of debenture holders. We also have the register of charges. We also have the register of beneficial owners. Go and read section 93A. And then we have directors' residence. We have the secretaries register. We also have the register of the directors themselves. So those are some of the statutory books and records that are normally kept by the company. That's what basically I was trying to extract from Veronica, Mr. David. And I know, David, last week, there were certain things I was supposed to address, but time ndio hii tena nimetukata nje. So long I was supposed to, I asked him a question on discovery, na ni kama time imeenda. I was supposed to address it this week. Maybe next week we'll do it. And then the issue of difference between an easement and a license. So, David, my apologies on behalf of the panelists. We'll tackle it. Just be patient. We'll address your concerns. Thank you very much.
Thank you also. Thank you for remembering that. I appreciate. it's good that our lecturer also undertook to cover that in our last lesson next week, so we may not lose much. Thank you so much.
Thank you very much. Hopefully, we'll meet up, and unless any of my colleagues have something to say, Alex, Noah, and Lavins, we'll close up today for that. I hope it was an interactive session. Thank you for attending. All the best. We're praying for you. You'll do great.
All the best. Until next time. Goodbye.
Thank you.
Thank you.
May the Lord
Thank you.
Thank you.
Thank you.
Thank you.